And here's how to do it. Number one, you only have 90 days from the date the final judgment is issued in the lower court, usually the appellate court, to get your appeal filed in Washington. And that means received, not mailed. You missed the date, 91, 92 days, your appeal's kicked out. Number two, you can file what's called informa pauperis. The fee for filing a United States Supreme Court appeal is $300. But if you're indigent, you have very low income, you're broke, you could file informa pauperis. That means you file a petition, an extra petition, and you state that your income is whatever it is, but it's not sufficient, in your opinion, to be able to meet your $300 fee. You then submit 10 copies of your brief, 10 copies, plus one, that's 11, that you're going to mail to the United States Supreme Court. Now, what does the brief consist of? Recognizing that the United States Supreme Court are only 9 justices, 9, in a country of 300 million people with a lot of controversies. Therefore, they only have time to accept less than 1% of the cases that are sent up to them. Now, there are those of us who feel there should be more justices that would allow more appeals to be heard, but for the time being, right now, and for purposes of our discussion today, that's what we have to deal with. So, out of every 100 cases sent up, only 1 gets accepted. How do you get your case accepted? And I'm going to tell you how. First of all, you have to recognize that the Supreme Court is not there to correct errors of lower courts. Shocking, but it's true. They don't correct the errors. What they're looking for are issues that involve more than just an individual's case. They're looking for issues that involve the entire nation, for example. Issues that they may affect discrimination of disabled people. They're also looking for issues of inconsistencies within appellate courts and inconsistencies within state courts. The Supreme Court would like the law of the land to be consistent among appellate courts and among state courts. So if you could raise an issue where your particular issue is in flux, one state may rule on your issue one way, another state may rule on your issue on a different way. The Supreme Court might be interested in listening to that. I'll give you a quick example. AEAE's issue is there should be a review process for discipline actions which are brought in states when an administrator declines to investigate an attorney. There should be a review process. In the state of Illinois, there is no review process. You file a disciplinary complaint, there's no review process. If the administrator, who currently is Jerome Larkin, should decide not to investigate. In the state of California, Arizona, Oklahoma, Texas, Florida, Michigan, just to name a few, all those states do provide review processes for parties who bring a grievance against an attorney and the state bar decides for whatever reason at the first level not to prosecute that attorney. You can file an appeal and they will give it to 3 other qualified attorneys to review it, not in the state of Illinois. So therefore, AEAE has been campaigning and raising a lot of Supreme Court cases involving the fact that other states allow the review process on disciplinary complaints and the state of Illinois doesn't. Therefore, the United States Supreme Court should step in and correct the issue. You have to think hard about framing the question, because in every appeal that you bring up to the Supreme Court, there's a question of law that you have to raise. And that question might be such as something that would say, which would state in our case, that there's an inconsistency among states regarding prosecuting attorneys under the rules of professional conduct, and whether such inconsistency violates due process and equal protection. The Illinois Supreme Court has consistently declined to change the rules for us, when we've appealed many cases there. I have. So the bottom line is, you can file a writ of certiorari, an appeal with the Supreme Court. You have 90 days in which to do it from when your decision is made. You file it along with a petition or a motion saying that you're in forma pauperis. You need 11 copies, 1 original and 10 copies, and it has to be received by the Supreme Court within 90 days.